Okay, great. Okay, hi everyone. Hope you're doing well. I was actually asked to do a talk on case law and how it affects the property market. Now, when any legislation comes out, um, the all the attorneys and the advocates they all go look at the legislation and they're trying to basically guess which way it's going to be interpreted, and then two parties will go to court, and one will be found entirely wrong and one will be found entirely right, and then we get something called case law. Now, case law basically says every court that's underneath the court that made the decision in the court has to adhere to that finding, that order. So it's quite a big thing. It's an interpretation of the act, and then everybody else has to follow that interpretation unless you go to a higher court to take an appeal. And you've got the magistrate court, then you've got the higher court, and then you've got a Supreme Court of Appeal. And in certain circumstances, we've got a constitutional matter, you can go to the Constitutional Court. So you can go up higher and higher, but until it goes to the next court, these court cases are basically binding, they're law, and we have to follow them. Okay, so we're going to look at a couple of matters. So the first one we're going to look at, it was quite a recent court case where the case law you'll see there, it's City and Atlantic Real Estate CC, trading as Remax Living, and Smith and others. It was a high court matter, and basically it's around the effective cause. Now, you probably have run into this quite a few times where you've got to decide if you're the effective cause or not. And basically what happened here, Remax had a joint mandate with another agency. And both agencies had this joint mandate with the seller, and they both had the right to market and sell the property. Remax had a client that was looking to buy a property, and they showed the property to the client various times and eventually put in an offer. The seller eventually didn't take the offer because the amount was too low, and basically the mandate period elapsed, and Remax thought, well, they're done and dusted, their time is over, and they went away. But what basically happened is that the potential purchaser that was introduced to the property by Remax went to the other agency that had the joint mandate, and they asked for them to present a new offer to the seller. Now, this was actually outside the mandate period for both of these agencies, but the agency went through to the seller and said to them, we have a purchaser for you, and it was a higher amount. And the seller accepted the offer, and the sale went through. Once Remax found out about it, they went and they proceeded to the courts, and they issued summons for their commission against the seller. Now, the seller is the one that's actually gets sued because they're actually liable for double comm in certain circumstances. The other agent, if they've breached one of their duties, obviously they can be referred to your board, but the person that actually gets sued is the seller. And what basically happened is the court said there's two things you have to prove to be the effective cause of the sale. Number one, you have to have a mandate agreement. Obviously, I can't just go and sell John's house down the road and say, listen, I've sold your property for $50 now on commission. So you have to have a mandate to sell, and then you have to be the effective cause. The effective cause is a very broad subject if it's an effective cause. There's been court cases where an agent was running late. There was a car that was traveling behind him with a potential purchaser, and he put his arm out the window and pointed towards the house. That purchaser became a signing purchaser and actually did a private deal with the seller. And the agent took him to court, and the agent won. The court said that was enough to be the effective cause. But there's also court cases that wouldn't have been acceptable. So it's been quite a difficult thing because the courts have interpreted effective cause in various differences, with small little differences in between. So basically, effective cause is when the estate agent introduces the purchaser to the property and or the seller, and that results in the eventual transfer of the property into that purchaser's name. Now, at this moment when the market's very bad, I often have estate agents coming to me and saying, Garth, there was a mandate agreement, and there was an agency that went and showed the property, showed a potential purchaser to the property, but the purchaser does not want to work with this agency. They said it was terrible service and they want to work through us. Can I go and sign the offer to purchase with this potential purchaser that was introduced by the previous estate agency during their mandate period? And unfortunately, in general terms, no, because they're the effective cause. That agency had introduced the purchaser during the mandate period and they're entitled to their commission. So if you go and sign a new offer to purchase with that purchaser, the seller will be liable for double comp. And obviously, they're going to take legal action against you for not advising them correctly. But that being said, there is a way sometimes to get around it. There is what the courts call a supervening event. So think about it. You're on a highway, you're traveling forward, and you're the effective cause. But the sale doesn't go through for some reason, and you have to take a detour. If that detour is big enough, that is what the courts have said is a supervening event. Now, I'll give you an example of a supervening event where the effective cause basically was detoured away to the new agency. There was a court case, and basically the agency had a mandate. They showed the property to showed a potential purchaser to the property and to the seller. And after the mandate period, the purchaser went to another estate agency, was showed around the property again, and signed an offer to purchase. And that first agency tried to sue. What the seller said is that when I was initially introduced to the property, I would have never bought the property because I have a full-size snooker table, and the property wasn't suited. But when the second agency showed me the property, they indicated that the wall between two of the rooms was a non-foundation wall and it could be knocked down. And due to that advice, I went and bought the property, and the court said that was a supervening event. But it's very difficult to know what's a supervening event. A lot of people ask me, Garth, is it if I can get a higher price on the purchaser? A higher price is not enough to be a supervening event. It can be one element of it, and there might be different elements, but it's not enough on its own. So what I'm saying to you is that if you've been the mandated agent, first up, every purchaser that you go and you show a property to, keep their details and go and check up on your properties that when your mandate lapsed, that those purchasers don't go and buy either directly with the seller or through another estate agency. If they do, you can come through to me and we can go obviously see the seller. If you're the second property petitioner on the matter, and you wanted to go ahead with the sale after the first property petitioner's mandate has lapsed, then we have to say, okay, they were the effective cause. They did introduce that purchaser during that mandate period, but is there a supervening event? And then we'll take a whole lot of considerations into factor, and then we can make a decision. Is it worth you going, taking the risk with it or not? And you're more than welcome to contact me anytime if you want to consider if there's a supervening event. But very interesting case, Remax won it. The seller actually paid double com, and they obviously paid it to the second agency already when it registered, and then they had to pay Remax their com. So they actually paid double com on the matter. Poor seller. Huh? Okay. Okay, so this is quite interesting. There's been court cases on this, and it pops up when you selling agricultural holdings. If the agricultural holding is a certain size and there's multiple people that want to buy it, sometimes you can't go and sell it to multiple people. And how you determine if you can sell it to 1, 2, 3, or 5 people, whatever it is a weird thing called the size of a Morgan. And our Morgan, if you look on the notes there, is, let me see, 8,565 meters squared. So it's a very random number, that. But basically what it means is that long as that every purchaser that's going to buy the property, the agricultural holding together with the other one, it's got to be bigger than 1 Morgan each. So if there's 3 people buying, and it's 1624, let's say 15,000 square meters, then you can't go and sell it to the 3 people. If it's bigger than obviously 3 Morgan size, then you could sell it to 3 people and they can sign it. What is the way that we get around it? We get around it in 2 ways. You can either we can try to get the 3 people to buy the agricultural holding that's smaller than 3 Morgans, and you can approach basically I think it's the agricultural department, and ask the minister for consent. It takes forever, so I don't recommend that. But the alternative route, if 3 people, like business people, want to buy it and they can't buy it due to the size of the property or the shares of the size of the property, then you can go register a trust or company. And then the company or the trust can buy it, and then it's only 1 seller, even though there's 3 trustees or 3 directors, and that's the way to get around it. So if you see agricultural holdings, there must be a light bulb that's going off your head if there's more than 1 purchaser. If there's more than 1 purchaser, is every purchaser buying a portion of the property that's bigger than a Morgan? Yes or no? And that will lead you where to go. Okay. Sorry, the computer's slow. Okay. So we're going to look at building plans, and why the building plans is coming quite an issue is there was a court case, you'll see halfway down. It's called Ordendale versus Ferreira's 2008, and it's a Supreme Court of Appeal case. So unless somebody takes it to the Constitutional Court for constitutional reasons, this is the highest decision that we can have, and it's not going to get overturned. And it's very unlikely that someone's going to take it to the Constitutional Court. And why that is that if you take a matter to the High Court, an application will probably cost you around about 100,000 Rand. If you go to the Supreme Court of Appeal, it's about R1 million. And if you go to the Constitutional Court, it's 5 million Rand and upwards. So very few people approach it. Okay. So, but basically what it says is that if the seller sells the property and there are buildings that are not on plan, and the seller sells that property, those that issue regarding the non-approved plans falls under the footstoots clause. Now you can just imagine how upset the purchaser is going to be, buys a property and half the property isn't on the plans. And as you know, the only way to overturn the footstoots clause is to show that the seller knew of the defect and hid the defect with the intent to defraud the purchaser. And fraud's very difficult to approve. So what do we have to do? First of all, I'd always recommend at mandate stage, try to go get the plans at that stage. Banks are asking for the building plans more and more and more and more. So even though the seller can rely on the footstoots clause in theory, it's a scenario that the purchaser will get a bond, and then they'll just say, well, you got to give me the plans because I can't carry on with the bond because there's no approved plans. And the seller says, well, I've got this court case and I don't have to do that. And there's a stalemate. That's the first thing that you must look out for. The second one that you have to look out for is if you're using another estate agent's offer to purchase. There are 2 different clauses regarding suspensive conditions when it comes to a bond, and they have very, very different interpretations, the courts have said. Okay. So the first one is that if the bond and the agreement states in there, if it states that it's on the usual terms and conditions. Now, the usual terms and conditions of a bank is not to have approved plans. Then the subject to clause has not been met, and the purchaser can walk away. So if you read somebody else's offer to purchase and you see those words, usual terms and conditions, light bulb must go off your head and you need to change that. It gives a way out for the purchaser. They'll get a bond. They'll ask for the plans. The seller doesn't want to give it, and they can walk away because of those words. The other one, the other term, which is much better, and you must always ensure that your contracts have it in regarding the bond, is that it's approved on the terms and conditions imposed by such financial institution. So obviously, if the bank imposes that, the suspensive condition is met. So it's very important that we have the correct wording there so that we can obviously ensure that the suspensive condition is met and there isn't a loophole for the purchaser to get out. So using somebody else's offer to purchase, just look at that subject to clause. It could cost you substantially. You can just imagine if you sell a $5 million property, person gets bond, they ask for plans and the seller won't do it, and now you can't sue for your common. It's a disaster. And then I can't even help you, okay? So we're going to go down here. Sorry. Okay, let's look at the next one. Sale of property, sale of business, and sale of members' interest. I put this in here because there's been quite a few court cases that have been popping up, and I've actually dealt with a couple. And this is where property petitioners make a lot of mistakes. Now you got a property that you're selling, and the seller says, listen here, I have a company or CC that owns that company, and they might even say, I've got a business that is running from that company. I'm doing a B&B, or I look after children in the mornings or something like that. And you've got to make sure that you use the correct offer to purchase. If the purchaser is buying the property out of the CC or the company, it's a normal offer to purchase. The seller's a CC or company, and they're buying the property out of the CC or the company. They're not buying the CC or the company. So that's your offer to purchase. That's number one. Number two is when the seller says, I want to sell the CC or the company. That is a sale of shares or sale of members' interest. That agreement is different from an agreement of sale that you would normally do. And I see often estate agents get to the house, the seller states it, and then you stuck because you don't have that agreement. And what they do is they try to take an offer to purchase. They write sale of share members' interest or sale of shares, and it usually doesn't work out. So with those matters, please give me a call and I'll help you draft the sale of the shares. Then there's the third one, and this one is often made a mistake. This is where the purchaser wants to buy the business. So it's often associated with the property. So if there is a child care center on the property, they'll say, I want to buy the property and I want to buy the business. Now, this is not buying the shares or the members' interest. The seller will still own in inverted commas, will still have the company or the CC, but they will buy the business. So that's the good rights of the business, the clients of the business, the credit, the debits, and all that. And that agreement is very specific, and then you must contact the attorney to draft a sale of business. If there's certain things that are not in there, not only will it be invalid, you'll open yourself up for litigation because there could be various tax implications, including that the parties often want to zero rate the sale of a business. If you don't do it correctly and they have to start paying VAT, and or the seller hasn't loaded onto the purchase price and he gets a less amount, you can just imagine the litigation that happens on that all the time. So remember, if the property is being bought out of the CC of the company, it's an offer to purchase, the normal one. If they're buying a CC, the actual CC or the company, it's a sale of shares agreement or a sale of members' interest agreement. And the third one is where they're buying the actual business, not the shares, could actually buy the shares with it or the members' interest with it, but it's an additional element to it. They're buying the actual company that was being run by the seller there, and that's a sale of business agreement, which will include your offer to purchase in there with the property and all that, and that must be drafted up by attorneys. It's usually quite a complicated agreement. Okay, so very, very important that you differentiate between the two. Okay. I'll skip one there. Okay. This is popping up now, and we've had applications that had to go through the court. If you bring a High Court application to a court, it's usually probably about 50 to about 120,000 Rand. You need to pay upfront to your attorney to bring the application, and it's very expensive, and it can delay the transfer. And this is what happens is when there is a company or CC and the company or CC has been deregistered. So you'll often go and you'll look up a company or CC and it'll say it's in the deregistration process. That's still fine. It's still in the process. It's usually because they haven't paid SIPs or they haven't provided their financials. But if the company or CC doesn't provide the financials for 2 years running, the company gets deregistered. If you go and you look up before you sign the offer to purchase and even the mandate agreement, you must go and see if the company or CC is deregistered. In South Africa, if a party disappears, which basically a deregistration of company, they disappear, everything in that company belongs to the state, it belongs to the government. And there's two ways, basically, you can try to get your property back, try to get your company back. Is number one is to go to court, which sometimes we have to do. And sometimes you can write your SIPs and you can explain why you didn't submit your financials, why you didn't pay, and you have to have a good reason. And if you don't have a good reason, like I said, you're going to have to go to court, and this could delay it. If it SIPs, probably about 2-3 months, maybe even a little bit more, for you to get the sale to go through, just to get the company registered again. And if it's got to go to court, the High Court is so backed up at the moment. A lot of matters are taking between 2 and 4 years to get a court date, and you can just imagine you're not going to waste your time on that. So it's very, very important that that you go and you check if the company has been deregistered or not. And there's the court case over there. It's Miller and others versus Natcock Investment Holdings, CO Limited, and others. And I went to the Supreme Court of Appeal because the company was deregistered and the state said, it's my property, it's my goods in there. And the guy obviously wasn't, the directors weren't that happy about it. Okay. Sorry, just the last thing on a company or CC. If the company or CC, and just remember this because this is popping up more and more often, is selling the majority of the assets in the company or the CC, which you can imagine if a company or CC has one property and they're selling it as the majority of the assets, then you need 75% vote by the members of the CC or by the directors of the company. We had a matter where there were 3 parties, there were 3 directors of three members of a CC, and the father and mother were together and they had 66%. And in terms of their company documents, they are allowed to vote based on a majority vote. The problem is the Companies Act has limited it to say it doesn't matter what your company documents say. If the majority of the assets are being sold out of the CC or the company, you need a 75%. And the third member didn't want to sign. So we got the offer to purchase. We phoned up the third member and said, listen, we need you to sign. And she said, nope, I'm not going to sign. And we didn't have the resolution to go ahead. And then the deal was dead. So very important, alarm bells going. CC company, is it the main asset in the company? Yes. Do you have a 75% voting right, or do you just have a majority? And that can be a big pitfall for you, okay? So very important to remember. Sorry, I see there's a question here. What would be the approximate time to finalize a court case on a commission dispute? Okay, so we see a lot on commission. It depends on various factors. So the first factor, are we in the magistrate court or are we in the high court? Magistrate court, if it's undefended, you'll get your judgment between probably 3 to 4 months, called default judgment, and that's they don't defend it. If you get a court date, it's anywhere from about 9 months to about 18 months, usually settling on about a year to get a court date. Now, the High Court is completely different. The High Court, if it's undefended, you can get a judgment in about 6 months, but if it's defended, the LPC says it's the average court case now, a post-court case for a summons is 5 years. So the courts are so backed up that you don't want to go to the High Court. So what can you do? If you're suing for an amount, say it's too much, it's going to the High Court, you can sue through the Magistrate Court and you just limit the amount that you're going to claim to the Magistrate Court amount. and you go that route rather, because you can just imagine 5 years, and you need an advocate to appear in the High Court. So you spend a fortune, hundreds of thousands of rands. So for the Magistrate Court, it's easy for us. We do a letter of demand. Well, the steps is that the purchaser breaches the contract. We go and then we place the purchaser on terms. It's called a terms letter, and then it gives them a certain time to rectify the breach in terms of the contract. On the day after they have to rectify the breach, we send a cancellation letter, and then thereafter we send a letter of demand for your commission. After the letter of demand for your commission lapses, then we have to unfortunately issue summons, and then we go through the route. And I would say about 50% of the summonses that we issue are not defended, and you get a default judgment 3 to 4 months, and 50% are, and then you go through the process, and plus minus, like I said, about 12 months. You'll get a court date, you'll have your day in court, and you'll fight it. Okay. Okay, so this is the last one, and it was a fairly recent court case. It was, I think, last year, and it was very, very interesting. There's different laws in South Africa, which makes it a little bit more difficult. And when you study law, there was 2 courses that I had to do called customary law. And I didn't understand that there was a law within our law. And sometimes customary law can take precedence, and sometimes they run parallel with each other. And customary law basically has said that there's something called a family home. So what basically happened is that the property was given to a daughter after the father died, and was registered in name in terms of, I think it was interstate succession. And she was the owner of the property. Now, there was all the family members that were in the house, and she said, well, it's my house, you got to get out. And she brought an eviction application. She won the eviction application. That matter was then taken on appeal to the Supreme Court of Appeal. And basically what the family members that were in the house said, we have been family members that have been in this house for 50, 60, 70 years, one after the other. This is a family home. It doesn't belong to one person, and the owner on the title deed, it should not be the owner of the title deed. It should be registered in the title deed that it's a family home. And it's not obviously all matters. It's very limited. And we'll see over here. It was a home in Soweto. Okay, so if you look at the history of the matter, the house property came into the possession of the Klamini family in the 1960s. Now, this was during the apartheid era, and people of color were not allowed to own properties in urban areas. So they couldn't have ownership of the property, but they had basically a right to stay there. In 1981, the law changed, and the Klamini family was issued a residential permit in terms of the Urban Bantu Residential Area Government Notice. So that government notice wasn't given to one person, it was given to the family. And that's why it was considered a family house. So you've got to check in 1981, was a residential permit given to the family? And also, the other thing the court said is that the family members must have been there all the time. So the different families can go in and out, but in general, the family members have to stay there during the time. And the final findings of the court was that they recognized the property as a family home, and they said this is a family house, and they took away the house from the owner with the title deed, the daughter. Then they said, number 2, they put a caveat on the title deed to say that the property is to be used as a family home, and that no one person can sell their property. And number 3, they gave an interdict against anybody evicting the family members. So very important, if you go into areas where there could be family homes like Soweto, then just find out, in 1981, that area, was there some kind of regulation given to the family to say that they have a residential permit there? And then you've got alarm bells that got to start ringing in. Then you've got to ask the question, did the family members stay in that property on during that time period? If the answer is yes to both, you've got a good chance that the property is a family home, and the owner that's saying sell the property can't actually sell it. In terms of the last one, the second one, the caveat on the property, no one can unilaterally sell the property. The whole family would have to sell it if they wanted to do it. So very interesting court case. Remember that we've got customary law and we've got what we would consider your normal civil law, and they often run concurrently and they intertwine sometimes. Okay, everyone, that's basically some court cases that were quite interesting. Is there any questions? Okay, I see someone is typing. I always say when you do a talk and you ask if there's questions and no one asks a question, you've either done a fantastic job because everyone understood, or you did a terrible job because no one understood it at all and doesn't want to look silly. So hopefully it's the first one.
Thank you, God. I think actually the message is quite simple: is don't get into commission disputes, and whatever you do, make sure you don't go to high court, because I think you could die waiting.
Definitely, it's. I mean, to be honest with you, after 5 years, your legal costs at that stage will be half R5,000 quite easily at that stage.
Yeah. There's a question from Rafiq.
What are the consequences if a company CC trust do not comply with FICA? So FICA is the same applicable to if you have to provide FICA, or if a company CC or trust. So if the company doesn't do it, the CC doesn't do it, the trust doesn't do it, then the directors, members, the members of the CC and the trustees will all get in the exact same trouble as if they had to do it individually. They will levy a fine against the company and against the individual directors, trustees, and members. That there's a duty on the company and the directors to be FICA'd individually and in terms of the company. And it's very important that if you've got a client who doesn't want to provide you with the documents, you can say to them, I'm not allowed to proceed further with this matter until I get the FICA documents. And if he doesn't want to eventually provide it, then you're going to say, I can't go ahead. And it's extremely dangerous what you're doing, because if you go and you buy a property and then one of the attorneys or the agents don't FICA you, and they find out, they're going to jump into all your books, and they're going to come and search for everything wrong with you. So let's just rather do it right and get these guys not to come in, because I've seen these FICA agents come in and they literally will tear everything apart to get to the answer. Great pleasure.
All right. Thank you so much, Garth. That was extremely insightful today. And I think, things that people are struggling with every day, and especially agents, as you say, market is tough, commission, who is entitled to commission. And you do get those clients that go, well, we don't want to deal with the other agents. We rather want to deal with you. So thank you. Very relative.
100%. If anybody, I'll open it up to everybody. If you have a matter where there is a dispute, who's the effective cause, is there a supervening event, please give me a call. We can have a look at it. I'm obviously not a court of law, but we obviously specialize in it, and I can give you the possibilities of success with the matter, and we can go ahead from there. Okay.
Super. Thank you, Garth. Have a great month further.